Welcome everyone to the IAPP web conference, Immediate Action Required, Navigating CPRA Compliance and Enforcement in 2024, sponsored today by Transcend. My name is Jordan Hardy, Programming and Speaker Specialist here at the IAPP, and I'll be your platform host for today's program. We'll be getting started with the presentation in just a minute, but before we do, a few program details. Participating in today's web conference will automatically provide IAPP certified privacy professionals who are the named registrants with 1 CPE credit. I also want to let you know that a recording of this program will be available in your My IAPP, My Purchases, My Recordings portal within about 2 business days. So if you just log into your account at the top right of our website and then go to My Purchases, even though you didn't have to pay for this, and then My Recordings, you'll see the title and you can click on that for the video and the slides as well. Please feel free to post any questions you have for the panelists throughout the program, and then they will have a Q&A portion at the end to answer some of your questions. Now onto our program, and I'd like to hand it over to our moderator, Cameron Ivey, privacy enthusiast and marketing manager at Transcend, to start the conversation. Thank you so much.
Awesome. Thank you, Jordan. And welcome, everybody. Good morning, good afternoon, and good night, if depending on where you are in the world. Appreciate you guys taking the time to join us today and our special guests. I'm super excited about this. A lot of good changes here for the CPRA, and let's go ahead and dive in. Let me introduce you guys to our speakers today. First is Jamal Ahmed. He's the global privacy consultant, author, speaker, educator, podcast host. He's many, many things. Wonderful, awesome person. Glad to have you here, Jamal. Thank you for your time. Also have Brandon. He's the general counsel and head of privacy at Transcend. So thank you, Brandon, for joining as well.
Thanks, Cameron. Nice to be with you, Jamal.
I'm super happy to be here.
And how are you guys doing today? Let's kick it off with that. Everything
Doing
good?
Great. Living the dream. It's a Tuesday. Excited about CPRA. Excited to help folks think about enforcement and risk and how to navigate.
Gotta love risks.
And I'm super excited. We get to bring almost GDPR-like standards for all of the residents of California, so they really too can enjoy that freedom over their personal information. And we're going to give some great tips on how you can just go about doing that today. So exciting stuff.
Yep. Let's go ahead and jump in. So key highlights here. Brandon, I'm going to shoot the first question to you. Can you walk us through the highlights that transition with the February 9th court ruling that overturned the delay of the CP, and along with that, what has been affected since the court ruling?
Yeah, happy to dive in here. The law, CCPA and then CPRA, and the way regulations have rolled out and how enforcement has sort of rolled out has been complicated. There's a lot of dates and a lot of procedural background. So I'll try to dive into this and then try to summarize the upshot as best as possible. And there's actually been a little bit of additional development here since that court ruling only a month ago. But let me start with some background. So back in November of 2020, California voters approved the California Privacy Rights Act, CPRA, and that amended the CCPA. A lot of folks still refer to the current law as CCPA. That is its official name. CPRA is the set of amendments to that, right? Mm-hmm. The CPRA included a number of new provisions and requirements on businesses. It introduced several new consumer rights. It broadened some of the pre-existing opt-out rights that already existed under CCPA. It expanded the definition of sensitive personal information, introduced requirements for risk assessments and audits on certain high-risk processing activities. But importantly, the CPRA also created this new California state agency called the California Privacy Protection Agency, the CPPA. And this is a new standalone state agency with the responsibility of proposing and adopting regulations under the amended law. It also has the power to enforce those regulations as well as the statutory law itself. To add some context, when we think about the difference between the statutory law, so CCPA as amended by CPRA, and the regulations, I like to think of the statute as sort of the broad what of the law. So CPRA says that there shall be a consumer right to opt out of sale and sharing of personal information. The regulations are the more specific how. So how must businesses go about honoring those rights? And this can include some very specific mechanisms that companies have to adopt to successfully honor those rights or honor those rights in compliance with the law. So CPRA said that the CPPA had to come up with regulations and finalize those regulations by July 1st, 2022. The CPRA also said that those regulations would be enforceable effective 1 year after that, on July 1st, 2023. But standing up a new agency, proposing regulations, going through the comment period, adjusting those regs, adopting those final regulations takes time. And in the CPPA's case, they didn't actually finish adopting their first package of regulations until March 2023. So that's 9 months after their deadline and only a few months before enforcement was set to go into effect. So in June of last year, the Chamber of Commerce sued the CPPA in California State Court and claimed that because of this delay in adopting regulations, businesses were warranted a grace period of a year before enforcement could begin, a year after the regulations were finalized. And the court agreed. They said that CPPA can't enforce its regulations until 1 year after those regulations were adopted. So they would become enforceable March 24th of this year. The court also said that the 1 year grace period would apply to any future regulatory packages that the CPPA adopts. So enforcement was on hold until last month on February 9th, when the Third District Court of Appeals in California ruled that the district court had actually erred. This meant that since the original July enforcement deadline last year, the CPPA was free to enforce its first package of regulations. It also meant that when the CPPA adopts new regulations, such as the proposed package it's working on now, which covers cybersecurity audits, risk assessments, and automated decision-making, that those regulations will be immediately enforceable once finalized. So that's the background and kind of where we stand right now, which is that this first package of regulations is immediately enforceable, currently enforceable by CPPA. With one update that I promised, which is that the California Chamber of Commerce has petitioned the California Supreme Court to intervene and actually reverse the appellate court. That is pending right now. So there does remain some chance that enforcement is again paused. But the upshot of this is that for the first package of regulations, right now enforcement can happen by the CPPA. In either case, the 1 year deadline coming up of March 24th, even if the California Supreme Court reverses, is only 19 days away at this point. So if you're not ready for the first package of regulations, it is time to get ready now. In the press release after the court ruling, the press release the CPPA put out, their deputy director of enforcement said, this decision should serve as an important reminder to the regulated community. Now would be a good time to review your privacy practices and ensure full compliance with our regulations. So they are very serious about ramping up enforcement immediately.
And really quickly here, who are they referring to? Who are they talking to at a high level?
Yeah, so they're really focused on the types of businesses that have to comply with the CCPA. So there are sorts of revenue thresholds and a number of records process thresholds. But for most businesses that are engaged in processing California consumer information, they are going to meet those minimum thresholds pretty easily by volume of records or by their revenue. And will need to be focused on figuring out compliance with the regulations.
Yeah, absolutely. California doesn't mess around. I love it. Jamal, just to add on to what Brandon just gave us, what do you think our primary focus areas should be to ensure compliance with CPRA from your perspective?
Yeah, so first of all, the businesses who will find themselves in scope of this, they need to really figure out what they need to do to be able to honor the new data protection rights. So, for example, the right to correct personal information, the right to limit the use and disclosure of sensitive personal information. Do they even know what sensitive information they have in the business? So it's about getting clarity, first of all, to say, hey, are we in scope? What are the definitions? What do they actually mean? And what does that mean? So lots of data mapping, just getting real clarity. That's the first thing they need to do. And then they need to have a look at, okay, we know that there are stricter consent requirements. So what we need to do is look at everywhere we're actually relying on consent, look at the wording and see if we need to review that. There's also new limitations on sharing data. What does sharing actually mean? Let's get clarity on where we are actually sharing that data and figure out how that's going to impact any revenue, any relationships, or how we might need to change and adapt to those. And then, of course, there's increased data security obligations. So you now have this flow down requirement, similar to what we have in the GDPR between the controller and processor. So it might mean that you have to go and review all of your contracts. And then we've got this new requirement of the purpose limitation. So it's no longer okay just to take that data and just because you have it, do some of the things or whatever comes up, but you really need to make sure that what you're doing is reasonably necessary and proportionate now. And so how do we define what that means? We probably have to update our internal policies. So different units of the business know exactly what they can and can't do with that data and what they need to do, which means it's also going to mean you're probably going to have to review your privacy notices and make sure they're updated in all of the places that they live to. But also, it's not all just bad news. This gives an opportunity for businesses to find innovative ways of introducing privacy-preserving technologies and methodologies. How can we actually make the most of federated learning and differential privacy to now set our brand apart from the competition? So it's also a great opportunity for businesses to take the lead here and use it to actually build that trust and position themselves in the market.
Yeah, that's a great point. Let's go ahead and move on to the next one. So primary focus areas when it comes to compliance. Brandon, what steps would you recommend in taking to manage CPR risks effectively?
Yeah, it's a great question and probably one that we will spend the rest of the morning chatting through in some detail. I think sort of before we double click into that, I just want to say one thing worth noting here is that while the CPPA couldn't enforce its regulations up until this February 9th ruling, and those regulations are really the most significant and specific and meaty requirements under the law. The CPPA is permitted to and had already been enforcing the statutory text of the law. In addition, the California Attorney General's Office, which had the previous sole enforcement authority under CCPA, continues to have authority to enforce the statutory law as well as its previous regulations. So not only does it have that power, but it has actually actively exercised that authority and continues to do so. So I think in the context of thinking about how do we manage CPRA risks actively right now, we have to keep some of those other risks in mind beyond just the CPPA's new ability to enforce. The Attorney General has focused on a number of enforcement sweeps related to the impermissible selling of personal information, focusing on mobile applications, platform providers, most recently OTT and video streaming providers. So enforcement of a lot of these core provisions was sort of already underway. So when I'm thinking about kind of what the steps look like for CPRA compliance, I think it really begins, as Jamal was alluding to, with data mapping, with understanding what information we're collecting and processing, and in particular, where that information is leaving our business, who we are sharing it to, where it is going, and accurate understanding of, in particular, how trackers are working and whether we are offering opt-out mechanisms that can turn off those trackers or turn off those data flows flowing to third parties is going to be crucial, not only under CPRA and the new CPPA's enforcement mandate, but also the way that the Attorney General is approaching enforcement already. So I would say data mapping is crucial and operationalizing opt-out mechanisms is crucial. I'd also highlight that understanding dark patterns, understanding what the CPPA's regulations say about what constitutes a dark pattern, and identifying where those could be on your website, and then doing a gap analysis and making sure you're adjusting those is going to be important, because if you have a dark pattern, the effect of that is that it voids the consent that you have received from that consumer. And that can have significant impacts downstream. And then the final one I'll highlight is to do a really close technical implementation on the do not sell, share compliance aspect of the regulation. This is an area where having an internal policy alone is probably not going to be enough to bring yourself into compliance with the law. The way that enforcement has rolled out, we've seen from the AG's office at least, is they are becoming much more technically savvy and sophisticated, and will be focused on not just a veneer of compliance on your site, like do you offer these opt-out mechanisms on your site, but when somebody selects that opt-out mechanism, is that actually effectuating an opt-out downstream throughout your entire tech stack and turning off that flow of data to that third party potentially. So these are all things that are pretty easily scrutinized by enforcement agencies, because they can get on your site, they can easily digest this and see this. So it's very visible. In addition, the CPPA is going to have, or has now, audit authority to dig in even deeper into the technical aspects of your system. So again, I would say beyond just the visible aspects of compliance on your site, you're going to have to dig down into your tech stack and make sure that you're connecting everything correctly, and it is actually operating in compliance with the law.
That brings a question for everyone. To consent or not to consent? All right, that was cheesy, but I like it. Now, Jamal, do you have anything to add to what Brandon just said there before we move on to the next slide to go deeper?
I think Brandon's done a really great job of delivering this in a way that makes sense, but also covering the breadth and the actual what we need to do. The only thing I'd like to add is the complexity that is required to meet the new requirements. So for example, one of the things we talk about is do not share my personal information. So previously it was do not sell, which was okay, companies got around that. But do not sharing adds this layer of complexity to data management practices, because now you have to find a way of efficiently processing those requests, but making sure that it's actually compliant across all your operations, rather than just the business unit that was previously selling this information. And then you got to make sure that all of your technical and operational adjustments are made. So some companies might need to actually upgrade the IT infrastructure and definitely the data management systems to support the new requirements. So what we need now is the enhanced data tracking capabilities to make sure those opt-out preferences are actually respected across all the data processing activities and also all of the sharing activities. And where it gets really complicated is trying to get clarity on those third-party advertising networks and relationships. And that's where I see a lot of people that are working with this on this are actually having lots of questions and challenges, but it's all good fun.
Yeah, good point. So deploying advertising technology under CPRA. Brandon, what strategies or measures do you recommend implementing to ensure compliance and uphold consumer privacy rights while still effectively leveraging the technology itself?
Yeah, I think the biggest thing to start with here is really data mapping. And traditionally, I think a lot of folks have viewed data mapping as a potentially manual exercise where you go around in your business and you talk to data silo owners or system owners, and you get them to fill out a survey and describe what information their system collects, why they're collecting it, why they're processing it, and you use that to sort of build an inventory to understand what data you're processing. For advertising technologies, when we talk about data mapping, it has to be a little bit more sophisticated than that for a couple of reasons. One is that the types of trackers that advertising technologies leverage these days have grown substantially. So the actual types of technology have expanded well beyond just sort of cookies, JavaScript cookies. So they include all sorts of SDKs within mobile apps, all sorts of first-party and third-party trackers, pixels, those types of things that exist on a site. I saw a statistic that there are, I think, 200 plus different types of trackers outside of what we consider sort of the traditional JavaScript cookie. All of those are potentially in scope for triggering obligations under the do not share requirements under CCPA as amended by CPRA. So doing a data map where you can actually identify all of the flows of data that are coming off of a browser and identifying where those are going, what URLs they're calling to, is going to be crucial to get a comprehensive list of where we are potentially sharing data. The reason I think this needs to be a more automated process rather than a one-time audit is these trackers change constantly. And marketing teams are always adding new technologies, and the use cases that they are engaged in change all the time. And these aren't always reflected in data maps that are done annually. Or if you are doing a data map, a lot of people do a data map through like a vendor management process. You onboard a new vendor, and that feeds into your data inventory as you go through that onboarding process. But once you've onboarded a vendor, those use cases can change, the types of trackers can change, and this is all very dynamic, and it moves very quickly. So a data map that is regularly scanning your site and identifying the data flows that are coming out of that is going to be key to doing any of these other steps on this list. So I highlight that as sort of the number one most crucial step under this.
So it's a lot too. To add on, Jamal, how does the CPRA ruling impact the evolution of this technology? Because it's obviously with AI, it's rapidly improving. What does it mean for companies under this?
Yes, so I think essentially what it means is advertisers and tech companies have to adapt their platforms and processes to now comply with these new rights. So that means they have to overhaul their systems to make sure that they can efficiently process the consumer request, respect their preferences, and that might mean that they potentially have to reduce the amount of data that's available for target advertising. Because of the way sensitive personal information is now introduced, that means that businesses have to limit that use. So you have to do what Brendan said, is go and do the data mapping and identify anywhere where you're talking about race, ethnic origin, religious beliefs, sexual orientation, personal communication, genetic data, etc. And then have a look to see, okay, what can we do with this, or where do we split it out? Or do we actually need to go and get that explicit consent to be able to use this information for the advertising and marketing? And then you need to have that shift towards being more accountable and having that transparency. So you need to enhance your actual internal data governance practices, as well as enhance your privacy policies to make sure that we are now operating in a transparent and comprehensive way. And that could involve a significant effort to audit the data practices across the organization. And one of the things that we see when new laws or regulations are updated or enhanced is often it's not just about the functional changes that need to be made, but it's more about the actual vitality, the culture of the organization, the practices, the kind of way people are used to doing things. All of that needs to shift. And so therefore, there's a lot of work that needs to be done, but it's not just a tick box exercise, it's an ongoing journey.
Yeah.
And I think companies need to kind of open up their mind to say, hey, this isn't just something we're going to tick the box and do, but we need to see how this is going to make changes, but also how we can actually use those changes to enhance our standing, our branding, and our relationship with our stakeholders.
Agreed. I think that goes along with the better training, more training when it comes to, like, obviously privacy, security training, instead of just kind of doing the normal old school style. But very good.
I think that's right, Cameron. I just want to sort of pull on that thread too, because when we kicked this off, you were talking about how much fun and how exciting this area is right now, and how it's constantly evolving. I think that companies that want to integrate privacy as a key component of their culture have to have that sort of mindset as well, right?
Right.
And beyond just sort of the traditional 30-minute annual security training slides that we sit through. I think privacy is unique because it is something that does affect us all as consumers as well. When we think about these rights, these are our rights, right? If you're
Right.
a California resident, as I am, this is one of my rights. And so I think it's easy to tie this into everybody's own life. Everybody sort of has their own personal information. They exist mostly online these days. And so so this can be very relevant in a way that some laws, I think, are not.
Agreed. I mean, that's why, not to squirrel moment and go off track, but that's why the Apple commercials, when they started doing the privacy commercials, were so influential when it
Yeah.
came to the tech space, because nobody else was really doing it like that. We don't have to dig into that, but anyways, yeah, we have to make it fun. I mean, it has to be fun. You have to make it fun for your companies, for your employees to want to learn and just become better when it comes to all these ever-changing rules in this privacy landscape. It's a lot to keep up with, and like we were talking about before, laws are not fun, but they can be, especially if we're having the right to protect our own privacy. So,
Yeah.
Okay. So you touched on this a little bit before, Brandon. And actually, no, Jamal, you also talked about, not sharing and all that kind of stuff. So, Brandon, with the enforcement now underway, ready to go, how do you want to ensure compliance with the do not share requirements? What are your opinions on that?
Yeah, so I'll give just a little bit of background here. And I think this is tied very closely to the advertising technology concept, right? So you'll recall that under CCPA, a sale was defined as the transfer of personal information to a third party for valuable or monetary consideration, and that consumers were granted the right to opt out of the sale of their personal information. So CPRA expanded this to allow consumers to opt out of what they call the sharing of their personal information. And under the law, sharing means the transfer of a consumer's personal information to a third party for the purposes of cross-context behavioral advertising, whether or not that is for valuable or monetary consideration. So just that sharing for that purpose, for cross-context behavioral advertising, counts as a share. So what are the steps? To prepare your organization, you're going to need to use that data map that we're talking about to identify all of the instances where you are transferring personal information to third parties. And then you're going to need to analyze each of these transfers to determine if it meets the definition of sharing. There are privacy technology companies out there like Transcend, but there are many that can help you identify that have sort of lists of third-party vendors and those that are likely to be engaged in cross-context behavioral advertising. So you can do some more complex, larger scale analysis of your data map to determine which of those may constitute sharing. If you are sharing data, if you've gone through this process and you determine with these third parties, we are sharing data, you need to decide on an opt-out mechanism that your business must support. And there are several of those to choose from. And then you need to implement and test those opt-out mechanisms to actually ensure that they're working. So those are kind of the four major steps that you need to march through in order to make sure you're bringing yourself into compliance here.
Awesome. Now, Jamal, can you elaborate a little bit further on the compliance challenges to add on to Brandon's for companies do not share requirements under this CPRA?
Yeah, so I think Brandon did a great job of highlighting some of the key requirements. The additional thing that I'd like to add here is we need to look at who we're actually in business with. So we need to look at the vendors, the third parties, because what we need to do is be able to have compliant relationships with those individuals. Now, let's say I've got information today, I'm sharing that with certain companies, tomorrow, let's say, Brandon, you're a California resident, you exercise your right to say, hey, I no longer want my information shared. That means I need to be able to trust that when that signal comes in and I pass it to the people I'm working with, that they will actually honor that opt-out request. So how do I do that? Do I need to renegotiate contracts? Do we need to look at specific terms that make sure that we're compliant with the CPRA? And how do we make sure that we can trust the people working with to handle those opt-out requests and restrictions out of any further sharing or selling of that personal information? So those are challenges that we're looking forward to solving. And those are challenges that businesses need to start thinking about how they're going to start solving those.
Yeah, agreed.
Hey, Cameron, I want to pause just on that slide quickly because we had a couple questions come in on this topic. So I figured it makes sense to
let's
address
do it
now. So we had one that was asking about the difference between sell and share. I think we covered that pretty well. And then there was a question on, is the disclosure of personal information to a third party for cross-context behavioral advertising, that is a share under CCPA, likely to also be a sale of personal information due to the other valuable consideration portion of the definition? So this is an interesting one. I'll give a little bit of background about how this came to be. So the sale concept was, the transfer of personal information for monetary or valuable consideration. But there were questions about how broad that definition should be read. And there were a lot of organizations that were engaged in cross-context behavioral advertising, but didn't believe that or took the position that that transfer of personal information did not meet the definition because there was no exchange of valuable consideration. The Attorney General's office in enforcing CCPA took a very different view. They viewed most cross-context behavioral advertising as being a sale of data. And we saw this come out when they were engaged in the enforcement sweep that led to the $1.2 million enforcement action against Sephora. If you go back and read that enforcement action and the settlement that came out of that, the AG's office identified all of the advertising tracking that was happening on Sephora's site, and basically said that their position is for any of this advertising technology, it constitutes a sale under CCPA. The share definition was added under the CPRA specifically to clarify that that should also be a right, so that there's no question on what the definition is there. So the long answer, but I think the answer is there's a big Venn diagram between these two. But for our purposes at this point under the law, if you are sharing data, transferring data to a third party for cross-context behavioral advertising, you need to offer an opt-out right to consumers.
Was there any other questions related to this while we're here?
I think those are the key ones. There's some dark pattern ones, but I think we'll cover those as we get further on in the presentation.
Okay. Perfect. Thank you for the questions. Keep them coming. So pitfalls. Love that word. It's super negative, but it's big here. So compliance pitfalls to avoid. Brandon, what are some of the major compliance pitfalls that we should try to avoid or be aware of?
Yeah, I think it's similar to what we have highlighted earlier, which is that enforcement authorities are going to start with visible compliance, what they can see on your site. And our view is that this is pretty low-hanging fruit for organizations to bring their site into compliance with. Right. So I would say the biggest pitfalls to avoid would be to not offer opt-out mechanisms for sale or share of information, to just sort of ignore that or hope that an enforcement agency is not going to look at that. It's an area where you can't really put your head under the sand because it is so easily auditable by just going to a publicly available website and looking at what trackers are doing. And I guarantee that the CPPA has very robust, web auditor technology to be able to go through a website very quickly and essentially simulate a user session and opt out of sale or share, and then see whether they are getting advertised to despite that opt out. There are technology companies like Transcend that offer web auditor type technology for companies to check compliance. So this is very easy to very quickly check that you are in compliance. Other areas of visible compliance. So dark patterns are an obvious one. And we'll talk in some more detail about kind of what those are further on. But avoiding confusing or choice architecture that is imbalanced are going to be areas where enforcement agencies are going to focus. And that will have significant impact because as I said earlier, it renders consent void. And then things like inaccurate or static data mapping, things that are not updated. I guess the other big one that I'll highlight that is tied directly into data mapping is having a privacy notice in place that does not accurately reflect your current privacy practices. So not fully disclosing what you are doing with information, the purpose for collecting that information. And this is going to be scrutinized by the CPPA. It's also something that is being actively looked at by federal enforcement agencies. The FTC and their actions over the last year have focused heavily on looking at what does a privacy notice say an organization is doing, and then what is that organization actually doing. And again, these are very easy to compare and contrast by just visiting a website. So I would say these are some of the biggest pitfalls that companies are going to want to avoid.
Thanks, Brandon. Jamal, on that same note, what do you see as the biggest challenges or challenge for all companies in complying with CPRA?
Yeah, so the challenges are going to be quite nuanced and multifaceted, but I think some of the key challenges that all companies are going to likely to face is coming back to what Brendan's mentioned a couple of times now. It's that data mapping and inventory. Understanding the full scope of personal information that's collected and created in business is something that many companies always struggle with, and creating and maintaining that accurate data inventory, especially when you have extensive data processing activities like the business in California tend to do, and the way you actually rely heavily on third-party vendors, that creates a massive challenge there, making sure that that data mapping and that inventory is actually accurate, update, but it's also maintained. And the other challenge comes when you're making changes. So look, everybody hates changes. Change management is something that needs to be managed sensitively. But where we have seen these rights being expanded, so for example, the right to opt out and the right of sending this information, the right not to have your sensitive information being used for cross-contextual purposes, whether it's sold for monetary value or not, that means we're going to have to make significant changes to IT systems. We're going to have to make changes to customer service protocols and internal processes. So unless we've invested in a great customer relationship management solution or a consent management platform that can handle these requests both effectively and efficiently, then that's going to cause all sorts of challenges trying to make those internal changes as well. I kind of mentioned this before, but working with third parties is always difficult. There's so much control and influence that you have over your own business, not so much over the people's businesses. So you must assess the privacy practices of your partners, update the contracts to include all of the data protection obligations. And that can be difficult because third parties are not always forthcoming with the information that you're after. They don't always respond within the time frame that you need to. And it's not sometimes because they don't want to, it's just because sometimes they might not even understand the question. They might be used to answering questions a certain way. So they might have a pack that they send you, or they might throw you to something that's been prepared by one of their lawyers and say, this is the standard information. But you actually need something a little bit more specific. So in my experience, that's been one of the challenging things, is actually getting the accurate and relevant information that we need to get good clarity on what's actually happening with all of the data that we're handling is often quite challenging. And then the other thing is when it comes to cross-border data transfers, if you are a company that operates globally, that adds another layer of complexity to an already challenging area when it comes to cross-border data transfers and complying with different international laws. So what you might need to do is look at how that might affect any binding corporate rules that you might have in place around the rules that you have in place for the sharing that you're doing. You might also want to have a think about how that might actually impact on any standard contractual clauses that you need to have, and whether you need to inform any of those European businesses of anything. From a European point of view, it's actually welcome changes that are bringing in, because it's bringing it closer to that essential equivalence that we actually want and need to have to be able to do business with companies based in California. So this is actually going to make business with California companies even easier, because you're coming closer to the standards that we expect from companies that share European citizens' data. And for California residents, it's also a great thing, because now they have almost equivalent protection to the global standard, which is GDPR. And so it becomes a lot easier for people to just say, hey, let's go with the highest standard, and let's make sure that we create a program or adjust the program to that higher standard, so we can actually future-proof our business. The other challenge that a lot of companies often tend to forget about is the training and awareness. Now, training is the education, awareness is the reinforcement of that education. A lot of the times I see people actually throw out a module of self-learning or have one session, and then they forget all about it. But it's actually remembering to deliver that training, make sure all employees understand their role in maintaining compliance with the CPRA, but also regularly creating that culture of privacy awareness throughout the business, where we're actually living and breathing the values that the CPRA brings in.
Couldn't agree more. And just to go back to your first statement about you and Brandon about data mapping and how important that is and accuracy. It's one of, I think one of the biggest problems as to why that is so important today is because before all of this, I don't know how many years ago, it was always about the perimeter. It was always about protecting the perimeter, but you can't protect what you don't know you have. So finding that data accurately is definitely one of the most important things to, because from there, obviously there's a lot of things that could go wrong if it's not accurate. Okay, great. So any questions that came through? That might be a good place to pause. I don't think so. We can always save those for the end too. So 7-step checklist for CPRA compliance. Brandon, could you kind of share a little bit about this checklist and how it's effective for CPRA and compliance for companies that can implement this?
Yeah, I'm actually going to cover a few steps that are even a little broader than what's on here as well. So in my mind, there are a number of steps that are sort of required table stakes things that companies need to do. So the first one is, as we've harped on sort of all morning, create a data inventory. A data inventory or data map is essential for understanding the personal information that your organization handles. And so that makes it crucial for CPRA compliance. You don't know what you don't know. And unless you go and discover it, you are never going to be able to actually do the gap analysis to find whether you have compliance obligations under the law for specific types of data you hold. That ties closely to number one on here, which is identifying and mapping sensitive data in particular, because there are heightened obligations around collection and processing of sensitive personal information under CPRA. It is also an area that is receiving extensive scrutiny from the FTC. And so as part of that data mapping exercise, it's not just knowing that you have personal information and where you're processing it, but knowing what category of personal information you have. Does it fall into a particular heightened or sensitive category? Is it health data? Is it does it meet those types of definitions? So knowing that is going to be important. The second part, we talked a bit about this already, which is determining whether you are sharing or selling personal information. And that starts with the data mapping process as well, but it then requires going a step further, identifying where that data is flowing to, whether it constitutes a sale or share, and then actually implementing the opt-out mechanism required. And again, so when you get to that stage of identifying a particular opt-out mechanism, there are a whole bunch of considerations you need to dive into. It really is an exercise of becoming pretty intimately familiar with what the regulations authorize businesses to do. So there are like really marketing friendly and advertising friendly ways to handle opt-out mechanisms under the law. There are linkless or frictionless approaches that are authorized if you are honoring things like GPC, global privacy control signals from a browser. You can have a way of opting folks out without having to pop up a banner to them, and you can make it a really easy, enjoyable consumer experience. But you're going to have to dig into those and make sure you are following the technical and specific requirements in order to implement those. So in addition to that, Jamal mentioned a lot earlier around once you've identified use of sensitive personal information, figuring out whether you need to implement limitation mechanisms in place, and ensuring that you are honoring consumer choices around actual collection of sensitive personal information. We talked about dark patterns a little bit already. Cleaning up dark patterns is going to be a huge part of this. Reviewing your data processing agreements with third parties, also going to be a major part of ensuring compliance. One area I don't think we spent a ton of time on was addressing the right to know and correct, which is an additional obligation under CPRA. So that sort of maps to number 2 on this list here, which is figuring out ways to respond to consumer requests and doing so for large businesses, doing so at scale. I don't think that manual DSAR processes are probably going to work in the future for a few reasons. One is just the volume of data that businesses are processing is too high to be able to effectively go around system to system and manually create, an access report to give to a consumer when they've requested one, and to do so within the statutory timeframes. And then the other piece of this is that data and systems change so frequently that having an automated tool that can easily pull these in and sort of programmatically generate the query that you would need to run on these is going to be much more scalable and much more effective, and probably save your team a lot more time than if you are running these processes manually. Revised privacy policies. We talked about this. You have to accurately state what you are actually doing with personal information. And if you are uncomfortable about stating that, then it probably means that you need to look a little deeper at your privacy practices and go through that change management process and make a change there. So those are sort of the key areas that I'm focused on. There's a few more on here, Jamal. I don't know if you want to jump in on here, particularly around obtaining consent from minors and dealing with sort of audit and security vulnerabilities as well.
Yeah, thanks, Brandon. And thank you for explaining all of those processes and actually giving us the detail of what we actually need to do. And one of the things I agree with is, look, we have our IT teams. They're experts on figuring out what it is that the business actually does best. But when it comes to understanding the nuances and how to comply with these things, it's always better to go and find an expert who's actually put the solution in their box. It's ready, plug and play. And the thing is, when something breaks, or if something was to break, then it's not going to take your IT team off whatever projects you're working on right now. There's a team there, that's all they're doing, is making sure they're maintaining that, fixing that. And as they're learning from lots of different businesses, they're always making those enhancements too. So I'm a big fan of finding really good solutions and making the most of them. I think what's really valuable for businesses when they think about implementing a systematic approach by using these 7 steps that Transcend has provided is to actually just take a step back first and begin with a comprehensive review to really understand the scope of the CPRA. What are the definitions? What are the actual requirements? And what's the difference between the CPRA and the CCPA? And what are the new obligations on us that we find ourselves in scope of? And then maybe have like a training session with the key stakeholders across the different departments, leverage external expertise, whether it's through counsel, consultants, or software where necessary, so that you have a thorough understanding of all of those legal nuances. Now, on the slide, it does say obtain consent from minors age 13 to 16. So if you are actually a business that is actually processing their information, then it's very important that you identify how you would figure out if they're minors or not. And also, you have to have a reasonable way of making sure that those minors have actually got an adult to give consent rather than ticking a button saying, yes, I'm over 16 kind of thing. So you need to kind of identify how you're going to be able to do that and demonstrate that you've actually taken reasonable efforts to make sure that it's actually come from a genuine person that is authorized to give consent on their behalf. He also mentions there on step number 7 about audit and address security vulnerabilities. So this is really important. We need to evaluate and enhance the data security practices that align with the CPRA's requirement for reasonable security procedures and practices. How are we going to do that? So the best way to really go about doing that is to conduct regular security assessments and risk analysis to identify what vulnerabilities that we have. And then what would be really helpful is to implement industry standard security measures and consider whether you want to actually go and meet a standard such as ISO 27001 or SOC 2. But working with the internationally recognized standards definitely helps. And there is no way that the regulator can come and say you're not doing what's reasonable because you're actually following a benchmark international standard.
Going back to number 6, I'm just curious, this is for both of you. Is there a reason why the age is from 13 to 16? Is this separate from any kind of like children's privacy? Do we know?
Yeah, so this enhances some of the protections that were previously provided under the federal law, COPA, though that is also being reviewed at the federal level, and we may see some legislative activity there. But under COPA, usually there's the sort of age of consent for online tracking stopped kind of at 13. This enhances that up to 16. This also gets paired with the age-appropriate design code under California law, which was modeled after the one adopted in the UK. So I would say if you are in an area where you are targeting your services to minors, or you have a good faith belief that minors are accessing and using your site and you are processing their data, you need to look at both the requirements under CPRA as well as the broader context and regulatory framework for websites that are processing children's data under the age-appropriate design code. So this is sort of one piece of or one tip of the iceberg in terms of children's privacy compliance.
Got it. Thank you. So it looks like we've got some good questions coming in. So let's open the floor since we have some time. What was the last one you went over, Brandon?
Why don't we I'll talk about dark patterns briefly because there's a couple questions on that.
Yeah, let's dive into that.
Cool. So there were some questions around what is a dark pattern. This is a concept that has been thrown around and is not always well understood. Fortunately, the CPPA provides some very specific examples. And they don't actually, I think, use the term dark patterns, but they describe what folks generally consider dark patterns. And so I'll just sort of talk through this. So under the regulations, a dark pattern is a user interface that is designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision-making, or choice. And so the way to think about these is, are these user interfaces designed to get somebody to do something that they otherwise wouldn't want to do or didn't intend to do? So under the regulations, consent obtained through an interface that employs one of these types of dark patterns is void. And the regulations also require businesses to avoid dark patterns in interfaces designed for consumer requests. So if you have a dark pattern in your DSAR interface or as part of that mechanism, or in your opt-out of sale or share interface, that would basically pull you out of compliance of offering that sort of right. So for this work stream, you need to work with your UI and UX teams. You need to use methods and language that are easy for consumers to read and understand, that provide symmetry and choice. So this is a very common one we see. Symmetry and choice means if you have an accept all button, you need to have a reject all button that's the same font, same size, same positioning. You need to avoid confusing language or interactive elements. So if you have toggle buttons that are confusing, where it's not clear which way toggling is an opt-out versus an opt-in, you need to avoid that. You can't use manipulative language or choice architecture. So copy that guilts or shames people into making a particular choice. We see these a lot when you land on consumer sites where they give you a discount ad in exchange for your email address. And if you are selecting no, it's like, no, I like paying full price. That sort of shame copy is considered a dark pattern. And the methods have to be easy to execute. So some of these are subjective, and it is an area where my guidance on this tends to be when you're designing your interface, don't have a lawyer be the one who reviews it to see whether there's a dark pattern. Don't have a privacy expert review it, and don't have your marketer review it. Have somebody in your business who does not touch any of those areas review that interface and give you feedback. And I think looking at sort of the reasonable person standard here is going to be the way to best evaluate whether an interface is manipulative in the way that the CPPA regulations prohibit.
We got quite a few questions that have been coming through. Are you both able to look at those? I guess we've answered some as well.
Yeah, there was one on here around whether a data map is required under the law, under CCPA or CPRA. I'll quickly answer that. The answer is sort of, but not really. So there is not a record of processing activity, sort of Article 30 type of obligation in the same way that there is under GDPR. But I don't see a way that you can comply with the law and perform assessments and manage purpose limitation and provide an accurate privacy notice or do any of the things that you need to do without a really comprehensive data map. There was also another question about whether a ROPA counts as a data map for these purposes. In my experience, record of processing activities under Article 30 tend to be more summarized versions of what processing activities are occurring and do not get into the granular technical details of where data resides and what data is there that you would really need in order to actually set up the full stack consent mechanisms that are going to be required under CCPA. So I would say a record of processing activity is a great thing to have. It's probably not sufficient to accomplish the compliance tasks needed here.
Yeah, I completely echo what Brandon is saying there. Because when we are creating records of processing activities, we can't create a record of processing activity without first understanding the complete life cycle of what's happening with that data. And that's what a data map does. It maps out exactly what's happening throughout the whole life cycle. And really good data maps show the different departments that are interacting with it, the different points of entry to that data, how that data is going to be used by different areas of the business, how data might also be created as part of that process. So what we need to do is get full visibility on what that journey looks like. Once you understand that journey, then you can take that information and put it into your data maps. But the question Brandon asked is, if you don't know what you have, how do you know what you're doing with it? And how do you know what you're not supposed to do with it? And how will you make sure that you have the controls in place? So although it's not a legal requirement, it's also almost impossible to be able to do something if you don't even know what you're playing with to begin with. And so I would say that is definitely the first place to start. It is not easy. It can be difficult, but there are lots of tools that can help with that. There's lots of approaches that you can take that will definitely help with that. But unless you have visibility on what you have, it's like the blind leading the blind. Nobody knows what they're doing.
Agreed. Is there any other questions that we could quickly answer? I know we're at time. I don't know if you guys have.
Yeah, I think we're probably at time here. I would advise folks, we may have I don't know if we have our LinkedIn information on the next page here, but
We do, yeah.
yeah, very happy to chat one-on-one with anybody who wants to dive into this anymore. Jamal, I know I'm sure you're very happy as well to take some questions post presentation. So yeah, love all the questions. I wish we had another 30 minutes, maybe even an hour to dig into all these.
Yeah, always happy to take any questions. And I can see there's a number of questions here asking about what are dark patterns. For a really funny example of that, I posted one earlier today on my LinkedIn. So just go and have a look at that. And you give an example of how someone's using language to manipulate or influence a decision. And that's all it is. What Brandon was saying earlier is we need to make sure that people have a free choice. So anything that influence or manipulates or uses psychology to take that free choice completely away from the customer would be what we call a type of a dark pattern.
Awesome. And everyone here that's still on, you guys are going to be getting a copy of the slides, I believe. So you'll be able to connect with us all on LinkedIn as well. So if you do want to reach out, please do so. Turn it back to Jordan.
Yeah, no worries. Thank you all so much. That was a great panel. Thank you to the audience, as they mentioned, for all of your very active questions. We love that. There is a link in the chat. You can't click it there. So there's a link in the chat for our brief IAPP survey on this webinar and future IAPP webinars that we do look at. So we appreciate any feedback that you can give us. Thank you so much for joining us today, and I hope to see you at Summit. Have a great one.
Thanks, everyone.